Well, hello and welcome to this webinar on inheritance tax and succession planning for UK property investors. Delighted to have you with us today. I'm joined by two experts who I'm going to introduce in a moment. But first of all, just to say, we're trying to keep this session interactive, so the chat and the Q&A are open. And if you have any questions on specific matters, very happy to bring those questions up to our panelists. So without further ado, I'd like to come to Zeeshan first of all for a quick introduction so we can get into the detail. Welcome to you, Zeeshan.
Hi, David. Thank you.
And Lorna, also welcome to you from Mitchell Moores. Great to have you on today.
Thank you very much, David. Hi, everyone.
So before we get into the detail, Zeeshan, it'd be great to hear a little bit more about your practice and how you just generally work with property investors on this topic.
Yeah, absolutely. So I'm a chartered tax advisor. I'm the CEO of Tax Consulting Group. We are an independent firm of chartered tax advisors, providing specialist tax advisory and consultancy services, partnering up with professional advisors such as fiduciaries, wealth planners, law firms, and in order to provide specialist tax services to private clients and corporates.
Fantastic. And Lorna, yourself, be great to hear more about your background.
Thank you. Yes, so I'm a partner in the private property and landed estates team at Mitchell Moores in London. And so I work together with my private wealth colleagues to look after high net worth individuals, family offices and trusts, particularly focusing on prime residential property, but also where we have clients who need tax advice, immigration, family law services, and the wider gamut of services that the full service law firm provides. That's what we do.
Fantastic. So, Zeeshan, just to get into a bit of detail on the tax side, we'll come to some of the key planning considerations in a moment. But why is UK property such a tricky asset for IHT? Why is it something that continually comes up and advisors need to look at carefully?
Yeah, so with UK property, David, the first thing to mention is that it doesn't really attract any reliefs, when it comes to investment property. So UK Citus, property investment portfolios don't really attract, relief such as business relief, albeit that's been restricted. Business relief has generally been restricted across the board since April 26, but properties, never really, subject to any relief. So, property portfolios either run individually, in the individual's direct ownership or via corporate structures will be subject to inheritance tax as a starting point. Also, the residency status of the investor is not relevant. If it's a UK Citus asset, it will form part of the inheritance tax net. There can be a misconception, especially when we, come to deal with overseas investors, that their residency status is linked to, whether the property portfolio will be subject to inheritance tax or not, but that is not the case. Any landlord or investor with a UK property, investment portfolio needs to review their inheritance tax exposure.
Does it come as an awful shock to overseas investors sometimes that the exposure is 40% of the value of that asset? They're just not aware of that.
Absolutely.
Something they've owned for some time.
We do come across that a lot. Yeah, absolutely. Yeah. So there is a lot of education needed there. Yeah.
So let's just walk through some of the key planning considerations when you're talking to someone who's got a pre-existing asset. What kind of things are you looking at?
Yeah, so the first thing to mention is that there isn't a one-size-fit-all approach here when it comes to inheritance tax strategies. It depends, as it does with a lot of tax planning, would depend on specific circumstances. Some of the key planning tools are, around, gifting, which is, so if you're, simple planning around gifting assets to the next generation, and the 7-year potentially exempt transfer rule, where you survive 7 years and the assets can be outside your state. However, commercially, we need to, review whether that works in practice, because obviously for that, we're going to have to give control away to the next generation. So, the client, each client would have to understand the commercial implications of such transfers. Obviously, capital gains tax also then comes into it, because any lifetime transfers will have capital gains tax implications. We also, look at trust planning. Again, a very misunderstood area, somewhere, an area where there's a fair amount of lack of awareness around, especially lifetime tax charges. So our inheritance tax is not only a debt tax, but it can be a life it can have tax implications during lifetime as well, especially with setting up trusts. Anything over the nil rate band will be subject to inheritance tax at 20%. So that's, one aspect to consider. Family investment companies are quite popular, which we'll come on to. So
Mm.
there are various strategies available, but, we always say to clients, well, our strategies are always bespoke and they're not mutually exclusive either. So, one, just because, we're looking at one option doesn't mean we can't consider the other. In most cases, we do look at a combination of different strategies that we can implement.
And there is a tension there, isn't there, between capital gains tax and inheritance tax planning, as you mentioned, because you don't want to be creating dry tax charges that might be
Yes,
difficult to finance. So, how do
absolutely.
those conversations often play out? When do people decide to take action and to swallow the capital gains tax bill, or do they just defer the decision because it's unpalatable to pay to be writing
Yeah.
a check?
Yeah, so again, it depends on, which strategy we go for. So, if there are, so let's say if the property does, if the portfolio does have, inherent capital gains, then, yeah, and if the client, we've had, a number of clients who will accept that there will be a hit now, but then for long-term benefits. So, capital gains tax rate is lower than inheritance tax. So, even if you were to pass some of the assets across to the next generation, yeah, take a bit of a hit at the lower capital gains tax rate for long-term inheritance tax savings. So again, it depends on each client's appetite, but from a tax point of view, solely it does make sense.
And what about corporate structuring? Have corporate envelopes that previously held property been taken away? Have properties been de-enveloped, or do you still see people using corporate envelopes? Where are we at on that?
Yes, so according to the old rules, which changed in 2017, we used to have so if you used to hold properties in non-UK corporate structures, that could have been outside the inheritance tax net. However, those rules changed, a few years ago. So now it doesn't actually matter if it's UK side assets. If you've got a Jersey entity or a Guernsey or an Isle of Man entity or wherever outside the UK, you can't get around our inheritance tax simply by owning property in an overseas in a non-UK corporate structure. We have actually done a lot of de-enveloping because of that, where the benefits of holding property in an offshore company, because the benefits have diminished, we are having to restructure and redomiciling or bring those properties into a UK corporate structure. Again, there's planning that is involved there, so we have to set up a group structure first, ensure that the transfer itself is tax neutral. But yeah, we have been working with a lot of investors around that. In answer to your question about corporate structures, yes. So overall, having property in a corporate structure it does make things a lot more flexible because it opens up, opportunities to undertake certain types of planning, which we can't do if the property is held in personal ownership. And we'll come on to the specifics
Mm.
of the options available, such as family investment companies.
Yeah, so if an investor today is not starting as such with a property portfolio, but with cash looking to make acquisitions,
Yeah.
how might they use, say, a family investment company or corporate vehicle to go ahead and start building that portfolio?
Yeah, it's a good question. So, yes, the first one there would be, firstly trying to understand, what the long-term objectives are, what the family circumstances are, who the portfolio eventually go to, whether, they want to start to look at succession planning in the near future, bring the next generation in. So the whole purpose of a family investment company is essentially, bespoke structure whereby we have the family, typically what that will involve is that the next generation will have, rights to future growth in value of the portfolio by being given what we call growth shares. So we can either set up a company as a family investment company at the outset, or, we might have scenarios, and, we see this a lot where the properties are already in a company owned by the client. But when they are ready to enter into the succession planning phase, we have to reorganize the company into a family investment company. And there's, a lot of work involved there in terms of ensuring that the articles are remodeled in the right way, the correct rights are associated with every shareholder. So typically it will involve freezing the state of a client so that their shares don't grow in value, and any future growth in value is then accumulated in the next generation state.
Thank you.
But overall, yes, a lot more flexible in a corporate structure.
And Lorna, just on the transactions you're working on, are you seeing people use like family investment companies, corporate entities who are building portfolios? What are you commonly seeing on the
To
transaction
a
side?
certain extent,
Yeah.
yes. I mean, one of the difficult things about corporate ownership is that if you're doing it for sort of tax reasons, there are sort of disadvantages for tax reasons. So you're putting yourself in the kind of ATED regime potentially, and SDLT charges on sort of the incoming transaction are a lot more difficult. Um, it's not as popular as it used to be
Mm.
honest. It's not something I'm seeing a lot of. Just I think a lot of our clients like to sort of hold property personally or sort of with family members. But I know it's a sort of a big part of the kind of options that are available for planning.
Thanks. And so Zeeshan, I mean, also talk to us a little bit about family buyouts or demergers when you're looking across the generations and restructuring of
Yeah.
portfolios, as you touched on in the end. What are some of the implications or ideas you're working on there?
Yeah, so family bouts have actually been very popular, for us recently. So a family bout essentially is akin to, sort of a management bout, which we see a lot in corporate deals and transactions. So it's using, similar methodologies and principles, but, whereby we would set up a new company which is owned by the next generation, and then they will take over the parents' shares in the company where the properties are owned. So if we do a straightforward transfer of shares to the next generation, that will give rise to immediate capital gains tax abilities. However, with a family buyout, we can get around that by relying on certain reorganization rules of the tax legislation, where instead of the parents being owed, being given cash, they are owed loan notes over time, and the legislation allows us to defer capital gains tax over time. We have to go to HMRC for clearance on it, but it's something that HMRC are, clearly have appetite for and have been accepting. So it's a very popular strategy actually that has been working a lot with families. However, one point to mention is that for such planning to work in practice, clients have to be willing to give control away. So it's typically suited for, landlord, property portfolio owners at the stage where they are willing to and can give, start to give that control away. But yeah, it has worked really well in certain circumstances.
And as Lorna mentioned, I mean, the preference for personal ownership now has increased given that the tax rules have changed. If people do have own property owned personally, it's about making sure, I guess, it's in the right generation's hands, but also
Yeah,
looking at things like life assurance or debt
yeah.
if on acquisition. What do you see if people do want have preference for personal ownership?
Yeah,
What
no,
should they do?
absolutely. Yeah, so Lorna's absolutely right in the sense that there are certain tax implications. So, a lot of the time there is that conflict between the immediate ongoing tax implications like ATED, like, the SDLT surcharge, in a company. However, it does increase state planning flexibility over time. So, in terms of property that continues to be owned in the individual ownership, yeah, absolutely. So until that, and if we don't do anything, then the inheritance tax exposure keeps increasing as the value of the portfolio grows. And if there are no other strategies, so for example, if the client's not at the stage where they're ready to start to, pass it on, then yes, we do work very closely with our financial advisor contacts, where we would look at inheritance tax policies, in the interim, essentially, until the strategies are implemented, or and also a combination of strategies. Because let's say we get to a scenario where we've undertaken planning which has reduced some of the exposure, but then there is some exposure left, and that can be inheritance tax policies can then be used as in conjunction with the other strategies that we've implemented for clients. So again, it's not a mutually exclusive solution. A lot of the time it works in conjunction with other planning tools.
And just to come to a scenario, say if we had a landlord with £10 million a portfolio and they're mixed use, they've got a variety of assets in there, they're looking at the inheritance tax efficiency. On that kind of client, what would you start, where would you start and what would you think about looking at?
Yeah, so the first thing to look at would be, what are the specific circumstances? So, the client's family situation, have they thought about, succession, who would they want the assets to ultimately go to? Because that will then decide which way we go down. There is, there is, for example, big misconception around trust, whether we go down the trust or the family investment company route. Again, not mutually exclusive, so we can also have structures where we could do, combination of both. So, um, with trusts, for example, we can't. So ultimately, it's the next generation that will be the beneficiaries, but then the client. So the investor will have some sort of control by virtue of being a trustee. So but equally, it's not everyone's cup of tea, because there is, compliance associated with trust. In those scenarios, family investment companies could be a lot more suitable. So it really is about working with each client and, looking at what their appetite is, and, going forward from a compliance point of view, how much do they want to sort of take on? But really, it's about asking questions around, succession. Who would they want the assets to ultimately go to? What sort of control would they like to exercise, short term, medium term, long term, and obviously long term as well. I mean, with what we are also seeing, also, quite a lot, is that, say if it gets to a point where control can't be given away, or for whatever reason the next generation is not ready to take over the portfolio, the client might look to exit completely, and then, we can implement structures that can lead to tax efficient exits as well. So yeah, that's that. It's certainly something to add to one of, to add to the strategies.
Thank you. And I'm just going to come to Lorna now, but just to say that if you do have a question or comment on the tax side, please do pop it in the chat, and I'll bring Zeeshan back on to answer. But Lorna, from your side, I mean, what are some of the key things with sort of some of the tax planning in mind, clients looking towards the transaction on the property? What's some of the things you start talking to them about?
So I suppose the very first thing really is to do this sort of ownership audit, because you need to start with the legal structure.
Mm.
And almost every later point depends on understanding how exactly each property is held currently. And so clients often talk about the portfolio, but legally it's actually a mix of properties in joint names, sole names, company ownership. There's mortgaged assets and there's tenanted properties. And so the documents don't always reflect what the family thinks is in place. So that sort of audit, ownership audit, legal and beneficial ownership is always the first stage to see exactly where everything is, what the information you have in front of you, and then you start with the end in mind, really. What's the client's ultimate objective with their inheritance tax planning, whether they're restructuring now in order to sort of get ahead of the issue, or whether they're looking to what will happen when they want to pass asset down to different generations.
Because I guess if that audit's not done, it can lead to unwelcome surprises in a probate or a divorce, or there'll be sometime it'll come to light where the family is relying on what they think is there, and having done that work, it'll at a time of stress, they could
Exactly.
add to their issues.
Exactly right. And I think one of the sort of the big surprises perhaps is around beneficial ownership. So quite often you'll see a client who's bought a property in his or her sole name, but actually he owns it jointly, sort of the beneficial interest in either equal shares or unequal contributions, depending on how they acquired the property. And so that sort of exercise around who thinks that they have some sort of economic interest in the property, it's really helpful to understand that sort of before anything goes wrong, to be honest, because you know what you need to do. And I think a big part of that really is making sure you've got declarations of trust in place, where you're sort of looking at personal ownership or a trust documentation, so you understand who the beneficiaries are, what their interests are. And then another point to consider really is unmarried couples. So it's
Mm.
sort of front of mind because there's a current government consultation about strengthening some of the inheritance tax protections for unmarried couples. But we can't plan ahead for the reform yet. You need to plan for the position as it currently is and think about what's going to happen if you and your partner, one of them dies before the other. And we're talking about, whether you're a joint tenant or a tenant in common, and what planning you can do now to make sure that things move the way that you want them to.
So is this the area of cohabitation agreements and things like that? What's the toolkit to kind of help make sure those issues don't come as a surprise?
So at the moment, you can either choose to hold a property as joint tenants or as tenants in common. And so if you're holding as a joint tenant, the owners are treated as owning the whole together. And so on death, the deceased owner's share passes automatically to the survivor. And that happens whether or not you're married.
Mm.
If you are tenants in common, then you might hold it as 50-50 beneficial interest or 70-30, for example, and that's something that you can decide and have documented in the declaration of trust. But what happens when you die is the co-owner stays holding their share of the interest in the property, but your share can pass under your will. So if you wanted it to pass to your children or to your surviving partner, you can actually prescribe how that will happen in your will as long as the two are aligned. Whereas you might write a will saying that you want to leave a property to your child, but because you're joint tenants, it goes automatically to your partner. So it's important to have an understanding of what the options are around that. And quite a common planning tool really is for people to sever the joint tenancy because they want to be able to control their sort of economic interest in the property. And that's something that, is quite easy to do. It does require some tax advice and planning to make sure that you are aligning the outcome that you want to achieve with your will.
And is it common for overseas investors to overlook a will on the UK assets if they're based abroad, or does that
I mean,
commonly get done?
Generally, I think when people acquire property, I try and advise them that it's a really good time to update a will or certainly to enter into a UK will when they have UK situs assets, because wills can very easily get out of date. And so when you've sort of done something new, it's a good time to review your portfolio, to review your planning for the next generation, check everything is up to date, and think whether it still works for you. And sometimes people like to do it sort of annually, every 5 years, every 10 years. I mean, I think generally if you're making a huge change like buying a significant property, adding it to your portfolio, you want to change how you're owning it and how you're going to pass it on, then I think you should do it quite regularly, to be honest.
Thanks. And the renters' rights bill is big news on the horizon. Perhaps you could talk us through that and why it will have an impact for landlords.
I think the biggest change, and everyone will have seen the headlines, is that from the 1st of May 2026, you're no longer able to serve a Section 21 notice to evict a tenant. And the advantage of the Section 21 notice was it was a no-fault eviction process, which meant that after the expiry of the notice period, if the tenant hadn't left, you'd be able to apply to the courts. And there's quite a sort of relatively swift process for you to be able to recover vacant possession of that property. With the Renters' Rights Act, we're now moved into a periodic tenancy model. And in order for a landlord to be able to recover possession from a property, they need to establish a statutory ground for possession. And some of the statutory grounds for possession include, the landlord wants to move back into the property or the landlord wants to sell the property. But the time frame that you can be able to recover possession in is a lot more uncertain. And because there's this reliance on the court process, could be talking months, if not years, if you have a process that's challenged by a sitting tenant. And so the biggest impact is obviously on timing. So if you're looking at your portfolio at the moment and thinking about how to structure it with an inheritance tax planning strategy in mind, you do need to have in mind how quickly you'll be able to deal with any of the assets that are let to tenants currently under the new regime.
And I mean, do you think that the regulation and also the tax position sort of tightening has made it less attractive for landlords to own property, or for bigger landlords to exist because they can actually deal with the regulations required? The tax side becomes more, the administration becomes more scalable. Have you noticed any trends in the last few years as to what landlords are doing?
I think anecdotally, there is very much a sense that it's a sort of hostile tax environment for landlords. I think people are quite concerned really about how they're actually going to realise any sort of benefit from tenancy portfolios. The regulatory framework is a lot more stringent now. I suppose the positives really of the new regime are that if you have a good tenant, you've done your vetting checks properly, you have a good relationship with them, you have a tenant that can stay there for as long as they want to, really. And unless you really needed to recover possession, you know that asset is going to be providing a yield for the foreseeable future. And I think that is a benefit. And I think also with the changes to sort of the non-dom regime, there is a behavioural change around whether or not people are buying property or choosing to rent for that sort of initial 4-year period. So I think we are seeing a lot more people interested in letting property, particularly high value property, even where you might look at it and think, actually, would you be better off buying a property rather than paying all this money in rent? It's actually sort of the market has changed very much in favour of lettings, particularly in London.
Yeah, Zeeshan, I mean, what's your sense of the trends for landlords, noting all these pressures that are being placed on the tax and regulatory side?
Yeah. So from a tax point of view, David, yeah, ultimately, we are seeing a lot more interest in divestments and exits. Albeit not fully, but having landlords who are obviously getting frustrated with the timing regulations. Especially in the UK, especially UK-based investors. We have been doing a lot of demergers as well. So, splitting portfolios into various clusters. So instead of, full exits, so let's say if you've got a 2025 property portfolio, splitting them into 3, 4 clusters, under the demerger process where, you could then sell off, 1 or 2 clusters to fund cash flow shortages and also future, inheritance tax liabilities. So that's something we are seeing a lot more of. Yeah.
And Lorna, just talk to us about some of the transactional angles. If there is tax planning being done, transfer of property during lifetime or transfer into a trust. What are some of the things that you headline for clients thinking about those things? Where do things go wrong?
Well, I suppose the first thing I have to always go back to the ownership point, because I think that is something that can really slow a transaction down if there's not sort of the real understanding of who needs to consent necessarily to a transaction. Another point is actually financing. So if you have a mortgaged property, you can't assume that your lender is going to be happy with whatever sort of restructuring that you want to do, and you need to make sure you're building time frame in to sort of get the lender on board, particularly I think where you're sort of moving a property from personal or sort of joint ownership with a partner to a corporate vehicle or a trust, so they can understand exactly what's going on and who the sort of parties who are involved and who's ultimately going to be on the hook to the bank. So it's the ownership piece, the beneficial ownership piece. Understanding actually your tenancy obligations. So obviously you've got some very high value leasehold properties, and if you're subletting those, have you got the right consents from your superior landlord? Have you done your sort of vetting to make sure that the tenants that you're bringing into the building are going to be suitable for sort of your plans, but also for the rest of the building? Are they going to be long term? And I think when you're using a trust structure as well, which is a very effective tool for inheritance tax planning, are you clear enough about how it's going to operate and how it's going to be sort of governed? So do you know who's going to act as a trustee, who's going to make the decisions, who's going to deal with tenants, approve repairs, that sort of thing? Who's going to be able to sort of decide whether you're going to sell or refinance property? It can be very effective tools, trust, but I think sometimes people misunderstand the extent of administration and sort of governance and compliance that there is with trust structures, and that matters really just as much as the tax analysis.
And in the event of death, what kind of impact does that have on the property portfolio? If how things haven't been done to get it in the right shape beforehand, often you can be dealing with it in a bit of a crisis situation with a lot of other stuff going on. How does that tend to unfold if things aren't addressed?
Well, I think the biggest point is that you'll probably be dealing with a lot of delay and a lot of uncertainty. And I think if you're sort of, we're talking in a scenario where a client has passed away without a will, so there's not really any effective planning about where properties are meant to go and their sort of next generations, or trust documents or corporate documents, and there's not been enough thinking around the trust documents and governance or around the corporate ownership as well, because obviously when you put a property into a corporate structure, the asset becomes the shares in the company, and understanding how you're going to sort of pass those on and who's going to get them and what sort of decision making is going to be made is pretty fundamental. It really helps to have thought of that beforehand. And I think one of the biggest advantages of doing your planning during lifetime rather than sort of dying without having thought about it is that you can be sure that what you have in mind is actually realized. So the sort of tax planning that you've set up, the structuring that you've done during your lifetime is going to hopefully yield that kind of ease of administration of your estate. It's going to ensure there's liquidity to pay any tax bills, or hopefully you've managed to reduce them in a way that is sort of meaningful for your estate. But really the worst case scenario is when you sort of pass away intestate, so you haven't entered into any kind of will arrangements, and then you're entering into a process where you're having to appoint administrators for your estate. They need to sort of work out what it is that you own, work out who it needs to go to. And people are often surprised when they're sort of confronted with how the sort of intestacy flow chart of who is entitled to inherit from your estate. And the biggest impact it has is generally on unmarried couples. And obviously, it does depend on the age you are at death, whether your parents are still alive, whether you've got adult children. But it can be a bit of a mess. And it's something that, to be honest, we should all really seek to avoid.
And are you seeing more clients using life insurance as these assets become more exposed and more difficult to plan around, so that there is liquidity, preventing the need for a fire sale? You can settle the
Yes.
liability and without the need for a cash call or sell the property quickly.
Absolutely, and I think it's quite a good tool for peace of mind because there has been quite a large increase in probate and will disputes because the value of property has increased so much over the last 20 years. It means that there's sort of much more meaningful capital value in people's estates, and that does enhance the sort of potential for disputes, but amongst family members, siblings, children from a previous relationship, and so there is currently a lot of litigation around who's entitled to inherit, whether or not they're happy with their share. So I think life insurance is one of many tools really that you can use to sort of try and protect against that scenario.
And I mean, just on a practical thinking, for property investors, what are some of the things that they should look at today? What's the sort of on the checklist?
So checklist, first of all, ownership
Yeah,
always. So do
yeah.
your audit, have a look at your land registry title, check that who you think owns it. Make sure you understand beneficial ownership as well. Do you have declarations of trust? Do you need to sever a joint tenancy? Do you need to take advice around that? Is your will up to date? Have you got a will? If you don't have a will, I think it's worth carrying out the audit section, sort of checking all your ownership, and then going to take advice around the tax, and then making
Mm.
sure your will aligns with all of that. And something that people actually forget really is incapacity. So, it's all very well planning for what's going to happen when you die and making sure that your assets are distributed the way that you want them to. But it's quite common for people to lose capacity during their lifetime. They're the sole owner or the principal of this portfolio, but they're the ones who need to make decisions, sign documents, speak to the bank, making sure you have a lasting power of attorney, which appoints a trusted individual to step in and take that role on for you, means that you can manage the portfolio when you're in this incapacitated state, whether that's through to disability or sickness or poor mental health or any other of the circumstances, which can happen sort of overnight. It just gives everybody that sort of tool to enable them to just continue running the portfolio because the tenancies will continue. You still need to collect the rent, repairs need to be sorted out. And so just having all of these sort of little tools in your toolbox make sure that everything sort of runs smoothly as best as it can.
And under that LPA might be a family member who's a decision maker, but then they can delegate decisions to a managing age. How does it? What's a typical kind of setup for someone going through that process of someone they trust to make decisions on their behalf?
Yeah, but I mean, people do tend to typically choose a family member, I think, because you're sort of entrusting somebody to make some quite important financial decisions. And they can be broader, so they might be sort of bringing in decision making around your own health. I mean, that's a sort of separate category, but with the powers of attorney that affect your business assets, it's common for it to be a family member, somebody that you trust. And then to the extent that they need to, they will essentially have the decision making and the signing authorities, but they can delegate to, say, a managing agent. If you're looking after a big rental portfolio, for example, I would expect that you'd have a managing agent looking after your sort of all of your tenants and making sure the compliance is done anyway. So in some cases that wouldn't really change. It's just the person they report to is slightly different.
Mm.
If you're sort of talking about a smaller portfolio and it's, husband and wife owning a few properties, two or three, some in their name, some in sole name, some in a company, then a lasting power of attorney can be quite helpful because it benefits you in all of those different scenarios if you haven't sort of collected everything under one sort of single umbrella like an SPV or a family investment company. It just means that somebody can step into your shoes and sort of take over and make sure that day to day everything's running the way it should.
In summary, on the renters' rights bill, it might just be a prompt to sort of review what the long term. It's another thing on the list of and more pressure for landlords. But what should the thinking be around renters' rights and potential implications?
I if you've got sort of tenants who've been there already for a long time, everybody's on this new regime now from the 1st of May. So unless you're sort of talking about very high value residential lettings, we're all in the Renters' Rights Act 2025, which means that you need to be thinking about timing implications. So if you've got properties in your portfolio that you might want to sell, or you want to transfer them into a trust or a company, or you want to restructure the way that you're holding these properties in any way, and that might involve needing a tenant to leave. So, typically there's that scenario being you wanting to sell. You need to make sure you're factoring in enough time to go through the process to make sure you can get vacant possession. And it's not impossible to sell a property with a sitting tenant, and some people do that. But I think if you need to sell quickly or want to sell quickly, then you really need to understand whether you're looking at 6, 8, 9 months, a year, 2 years. There's a lot of backlog in the court process at the moment. It's not something that's going to happen very quickly. So it's the timing implication that's the big one.
And Zeeshan, from your side, I mean, we've heard a lot there on the different implications, but the importance of having, tax and legal advice in tandem is one that's clear. I mean, you often working in concert with, I guess, bankers on the finance, law firms on the doing the transactions or reorganization, like we discussed. How does it work in practice with you?
Oh yeah, absolutely critical. Yeah, we can't complete any of our transactions without legal input. So, advice is one thing, but then, it doesn't mean anything until the formal executions done. So yeah, pretty much all our transactions, all our advisory pieces, do involve a lawyer for sure, as well as obviously on unencumbered portfolios, we do work very closely with mortgage advisors and wealth planners.
Lorna mentioned when there's bank finance in place, it can that can be a potential block to a reorganization. I mean, how do you find if you are doing some restructuring, there is some debt in place? How does that sort of play out? You
Yeah,
might need to look at other lenders, or
yeah,
what tends
absolutely.
to happen?
Absolutely, yeah. So a lot of our restructuring, we would recommend clients to look at specialist lenders. Obviously, it's, the mortgage advisors that will come into it, in terms of advising the client, but it's typically, specialist lenders. For example, we do a lot of property incorporations where if you've got a big, if you've got a large property portfolio that you're looking to transfer into a company, you have to then novate the debt across as well. So you can't just simply say, well, yeah, I'm just transferring the portfolio and the debt goes across. The lenders have to approve it. Not every lender would have the appetite for it. And in those sort of scenarios, we will be working with specialist lenders to refinance the portfolio and take out new funding in the restructured portfolio.
I think it's also just worth jumping in there to mention that sometimes the SDLT is chargeable on some of these transfers. So it's really important you take, proper tax advice around
Yeah.
moving property sort of between sort of smaller companies, closely held companies, family investment companies, trusts, and just make sure that if you are sort of creating a tax charge because you're assuming or releasing a liability, that you fully understand the position.
Yeah.
Thank you. Question in the Q&A from Susanna Quinn, just asking, I think this one for you, Zeeshan, just saying, have the non-dom changes opened up advantages for UK expats who've been overseas for 20 plus years coming back? I'll come to you, Lorna, as well for a comment. But Zeeshan, what do you think? Has it opened up anything new? The reforms that have come in.
Yeah, so specifically in relation to the topic of discussion today, directly not because UK status assets will, were previously within the inheritance tax net and still remain in the inheritance tax net. However, if you do come back in the UK having been non-resident for a number of years, yes, then you've got the foreign income and gains regime. So that's outside the inheritance tax. It can have other advantages when it comes to owning overseas assets, overseas property portfolios. So it has certainly been advantageous to clients that were non-resident for a long period and then come back to the UK because obviously the domiciliary rules have gone now. So yeah, it's definitely planning opportunities there. Yeah.
Lorna, are you experiencing any expats, long-term expats coming back because there is this tax advantageous regime and buying a new property to live in
I
coming here?
can't think of any, David, at the
No.
moment. I'm not sure I am, to be honest. No, I think one of the interesting sort of behavioural changes around that sort of expats leaving is that people haven't necessarily sold UK property. They're still holding on to it, possibly renting it out, or they've got sort of children living in it. So it'd be interesting to see longer term whether, people decide to come back, whether they start to sort of divest of portfolios or, reduce their UK assets. But no.
And we hear a lot of Americans coming to the UK as well, just anecdotally in the press. We read a lot about it. Is that something that you're seeing, or again, it's something that's frequently discussed, but is not necessarily. It's one of many destinations that American
Well,
buyers might come to.
American buyers are very active in London. They have
Yeah,
been really for the last sort of 18 months to 2 years. And, there's a lot of reasons for that. But I think just sort of capital value point, London's a lot cheaper than it has been for about 5, 10 years. So there's a lot of bargains around, so to
yeah.
speak, and particularly for dollar-backed buyers. There's a lot of interest, obviously, in London because of cultural similarities and language and schools and leisure and all the sort of advantages that London offers. But it's not actually just London benefiting from that. The Cotswolds has obviously absolutely boomed in the last 18 months in particular, and has been very appealing to American buyers too. But they're not the only ones who are active. I mean, Middle Eastern families are also looking at, particularly around the schools piece, university for children studying, short term, as in sort of 2 year stays in the UK. So
Zeeshan, you're very active with clients in the Middle East. What are you seeing in terms of what they're thinking about on the property front?
Yeah, so we are still seeing a lot of interest. As Lorna mentioned, there are some good deals around. We're not just seeing London. I think the interest across the regions has also increased. So we have advised, we have worked with Middle East investors looking to invest up north, especially Manchester, and in the outskirts. So yeah, UK still remains very popular amongst Middle Eastern investors. Absolutely.
And trophy homes, Lorna, in Prime Central. And I mean, there have been some big deals. There's a lower volume of transactions, but some big deals being done, aren't there? So you think
yeah.
there's still, London still does have that currency with high and ultra high net worth clients who want like spending time here and still want to invest in the UK.
Well, absolutely. And I think there's just so much sort of variety really in London for people to find the type of property that they like, and their cultural reasons why certain properties are more popular with certain communities from different countries. But US and Middle Eastern families in particular are very sort of focused on London. And long may that continue, to be honest.
Yeah, absolutely. Well, we're coming to the end of our session, but there is still time to pop a quick question in the Q&A or chat if you like, or afterwards, after this webinar, we'll circulate contact details for Zeeshan and Lorna so you can ask your questions direct. But I think absent of further questions, I'd like to thank Zeeshan and Lorna for their insight today. It's been a great session, and look forward to sharing this conversation with our